Hi, it's Roland Jones. This is another short video in a series of videos on preference and fraudulent conveyance issues. This is a 2011 district court level case. This case is about whether the ordinary course of offense applies to some transfers that were made by the debtor to the preference defendant in the 90-day preference period. A fairly large number was involved, almost 200K. And let's see what happens. Obviously, the debtor argued that the payments were made in the ordinary course, did a comparison of the year prior to the preference period and what happened during the preference period, and compared the days outstanding, in other words, how late the debtor paid in the two periods, and to establish ordinariness. And the defendant showed that the averages were very, very close, 35.54 days late on average in the preference period and 31.63 days late on average in the base period. Also, the defendant did a range analysis, finding that the payment range in the pre-preference period was between 23 and 65, and in the preference period between 22 and 70 days. So the defendant argued, hey, all the payments were within range during the preference period, were within range of all the payments made before the preference period. So the defendant argued that the payments were ordinary course. By the way, I'm a little biased. I represented the defendant in this case. So I happen to think it was a great defense and that I did a wonderful job. But anyway, let's find out if I actually did a wonderful job or not. I think you can guess. I wouldn't be admitting to being counselor the defendant if it didn't turn out well for my client. Anyway, we also argued that there was no unusual collection activity. So what did the trustee argue? And these were competing motions for summary judgment. Well, the trustee argued that, hey, you got to take a much closer look as to what really happened here. Comparing ranges and averages doesn't tell the whole story. And what happened here was that prior to the preference period, only 36% of the payments were paid within 0 and 29 days, whereas during the preference period, all of a sudden, that number jumps to 61%. So there were, in other words, the trustee made a grouping argument. He was saying that if you take a close look here, there's a big difference between the comparison period and the preference period. And what's the difference? Many more payments were made between 0 and 29 days in the preference period than in the base period. So it sounds like could be a valid argument. It looks like a significant difference between the two periods. So the issue was not that complicated. Can the unusually high clustering of payments in the 0 to 29 day period is that as opposed to the base period, where there are fewer payments in that bucket, 0 to 29 days, is that enough to take it out of the ordinary course? The applicable code section 547C to A, made in the ordinary course of business or financial affairs of the debtor and transferee. Well, I was very happy that the court found in our favor and basically said, hey, the trustee is coming up with an arbitrary comparison by focusing on this particular sub-period and comparing this particular sub-period in the base period to this particular sub-period in the preference period, and it's an arbitrary kind of analysis. And the judge found in our favor. The takeaway here is that the district court in New York, in the Second Circuit, found that you should pay more attention to a range analysis and a comparison of the averages. However, I have seen cases in other circuits where the trustee's argument in this case prevailed. Not exactly on these facts, but that is a concern, and the trustees are going to make arguments like that, and defense counsel has to be aware of those arguments and include that kind of analysis in the analysis of the case.